I'm standing inside the Washington County Iowa Courthouse, and it is January 20th, 2025. Not only is it Martin Luther King Jr. Day, it is the inauguration of our 47th president, President Donald J. Trump, and showing support for him today with the wearing of this hat. But the reason I'm here at the courthouse is because we're following up on the what I've been calling the Highland School District bond issue shenanigans. And today, Ron Greiner finally has his day in the court office with the folks from representatives from the school district and with an impartial judge and attorney. And we're going to show you all the proceedings, all the public portions of the proceedings. And this episode is brought to you by Greiner Auto Body of Washington, Iowa, using state-of-the-art techniques and decades of experience to get your car back on the road after an accident. Car Doctor of Washington, Iowa. No matter who Frankensteined it, they can fix and clean and customize it. McDonald Boneyard of Keota, Iowa, for all of your farm equipment and auto recycling needs. Hinshaw Trailer Sales of Richland, Iowa. You need a trailer. They've got your trailer, and they fix what they sell and don't in their full-time repair shop. Girling Repair of Winfield, Iowa. If your mower is dead, call Fred, your Husqvarna, Aaron's, and Gravely dealer, and Fred also fixes and sells snow blowers. B&B Propane and the family of Jet Stops. And Dutch Market and Coffee Talk of Washington, Iowa. Do you need a conference room for a business meeting, or you've got a family event coming up? They'll loan you that for free. Give them a call at Dutch Market. And also, please note, Coffee Talks drive-thru is open right now to serve you. And they all present the award-winning Southeast Iowa Today. I'm John Bain, author of Christie's Journey, The Beat Goes On, and your host. Let's go on inside.
It's 9 o'clock, and we'll call this hearing of the contest court for Washington County to order. Council are here. The panel is here. We need to be sworn in, so Madam Clerk, will you swear the three of us in?
I sure will.
You need to raise your right hand, each of you.
You and each of you do solemnly swear or affirm that you will well and truly try the issues involved in the election contest to the Highland Community School District bond election and a true decision render, and that you do solely on the evidence introduced and in accordance with the law of the state of Iowa.
I do. Thank you. We have no official court record. One of the persons here from media groups indicated that they could tape it, and Ms. Stewart indicated she could tape it. I don't know that this procedure requires a record, but there is of course, an appeal right to the district court. And what's your thoughts?
We're okay if it's not recorded. We can make a record just verbally.
Okay. Ms. Fink? Okay. We probably, and there are media folks here. I think this is open. I don't think it's an open meeting per se under Chapter 21, but certainly the public's right, got the right to be here and everything, so we'll proceed. As I indicated in my letter, and I hope you got a copy of the letter or was provided to you, what we'll start with is we'll take up the matter of the motion first, and then once we get that record, we'll move right to the merits, and then the panel will take up both of those issues and make a ruling on the motion. And as I indicated, if we sustain the motion, then we don't have to get to the merits, but if we overrule the motion, then we'll make a decision on the merits. So we'll proceed, and it's the district's motion, so you're free to begin.
Thank you, Mr. Gaumer.
The district did submit its position on the jurisdictional question here in both the pre-hearing brief that was filed as well as the pre-conference brief. Those are largely the same arguments regarding the jurisdictional defect in contestant's petition. Iowa Code Section 62 requires that the contestant file a bond and an affidavit along with the contest petition no later than 20 days after the canvass of the votes. Washington County canvassed its vote on November 13th, and therefore the deadline to file the petition, the affidavit, and the bond was December 3rd. Only the petition was timely filed here. The evidence shows that the bond and the affidavit were not filed until December 6th, so 3 days after the deadline. Here, the canvass of the votes that the petitioner has challenged, that the contestant has challenged, is based on Washington County's canvass of the votes. This whole petition concerns what happened in the Ainsworth precinct in Washington County and the results from the Ainsworth precinct. And so that 20-day deadline runs from Washington County's canvass of the votes. The Iowa Supreme Court has held that the failure to file a bond in a timely manner is a jurisdictional defect in an election contest. And this court therefore does not need to go any further in debating the merits of the contestant's petition. The bond was not timely filed, and we don't need to proceed further. The main grounds that we have set forth are already in our briefing materials, so I don't want to take up too much time repeating all of that information. I'm happy to answer any questions about the defect. Otherwise, that's all I have for right now.
Ms. Singh?
Thank you. So the Iowa Code Section 62.5 actually says, within 20 days after the Board of Supervisors declares a winner from the canvass of an election, the contestant shall file. And so what is key, as is noted in relevant case law, is the canvass from which the board declares a winner. Exhibits four, pages 1 and 2, demonstrate that the vote taken for the canvass done on November 13th, 2024 was an initial canvass done with just the Washington County votes. Page 2 shows that it was the final canvass done of all county votes on November 19th, 2024, at which time the Highland Community School District Public Measure BF was declared to pass. And so the key word in the statute is the declaration of a winner. And the Board of Supervisors did not declare a passage until November 19th of 2024. And that is consistent with what Iowa Code Section 27720 requires. It sets forth that for school elections such as a public measure, the votes are to be canvassed in the manner required by Iowa Code Section 50.24. In turn, Iowa Code 50.24.4 requires the controlling commissioner of each county to canvass the votes on the second Monday or Tuesday after the election, and then the controlling commissioner for the school district shall perform, or the county board of supervisors shall perform a canvass of all the abstracts submitted from the counties, which is considered the final canvass. It is this final canvass that the Commissioner of Elections declares, issues a certification as provided for in 50.27. Again, this certification is required by the statute. Mr. Widmer's certification is the district's Exhibit E. And if you review Exhibit E, it clearly states therein that the vote was cast and a tally lists were canvassed by the Board of Supervisors for each county. And then it indicates that the Board of Supervisors of Washington County did a canvass of all the votes. And it says these were held pursuant to Chapter 21, and that the certificate is being issued in accordance with the final canvass. Again, the final canvass being the canvass completed on November 19th of 2024. The case law supports this interpretation. In the case of Coney versus Malema, which is in Contestants Exhibit 5, starting at page 8. The court indicated the public measure at issue was confirmed when the results were certified. And it said, just as a statement of intent to contest the election must be filed with the appropriate authority within the period specified after the statute, after the election results have been certified. Further, in the case of AHST Community School District that is referenced by the district in their brief, it is key to note that in discussing the relevant case law, the Iowa Supreme Court referenced the case of Haas, which is also in Exhibit 5, starting at page 15. In the case of Haas, even as explained by the Iowa Supreme Court in AHST, the contestant in that case had filed the written notice of their intent to challenge the election before the board of canvassers had certified the final results. As a result, both the filing of the bond and the written notice of intent were premature. So clearly, the Haas case says notice is not taken until the final result is declared, and the AHST ratifies that the date that the 20-day time frame starts to run from is the date of the final result certification. So I think it's clear in this case that the measure was declared to be passed on November 19, 2024, and from that date is when the 20 days started to run. The contestants' petition, affidavit, and bond were all on file by December 6, 2024, making all of them timely, and there's no jurisdictional defect, and the judges should move forward on merits.
Comment?
May I respond? Yes, thank you. A couple points. I think it's important to note that here, the action that is being challenged stems from the county's first tier canvass of the results. Washington County conducted the election in Washington County. The school district is in 3 counties, so there were 3 counties conducting an election on the public measure. The first tier canvass that was completed was to verify the results in Washington County. The second tier canvass reviews the results from all 3 counties, and then that canvass is done to confirm the totals from all 3 counties. Yes, which is the second tier canvass. The first tier canvass is what the deadline runs from here. If we had a situation where I guess what the contestant is arguing would mean that there are different deadlines depending on if a school district is only located in one county or if they're located in multiple counties. I don't believe there's anything in the code that states that the deadline to challenge a county's canvass of the votes, to challenge the election, depends or is different, that 20-day deadline is different depending on if there's a first-tier canvass or a second-tier canvass. That deadline runs from the county's canvass of the votes, the first-tier canvass. With respect to the case law, none of the cases that have been cited deal with the question of which deadline controls the first-tier canvass or the second-tier canvass. In AHST, the court was very careful to calculate the 20-day deadline. It ran from the canvass of the votes, which in that case, it appears there was just one county conducting the election, and that deadline ran from the county's canvass of the votes. Here, the challenge runs from Washington County's first-tier canvass of the votes. That 20-day deadline started to run when Washington County completed its first-tier canvass of the votes. There's no challenge here to what happened in the second-tier canvass of the votes. That's where the county considered the results that had been canvassed from Washington County, Johnson County, and Louisa County. There's no challenge about that canvass of the votes. So when we're looking at whether or not there's a jurisdictional defect, what we know is that the code is clear that there are 20 days from the canvass of the votes, from that result being declared, for the contestant to file the petition, the bond, and the affidavit. Here, the contestant did not file, well, the contestant did file the petition within 20 days, but did not file the bond or the affidavit until 3 days after that. We also know from the exhibits that the reason that the petitioner was waiting to file that bond was to see whether or not basically to count votes and see whether or not it was worth proceeding. But the deadline of December 3rd was met for the petition. And so here, I don't think there's anything in case law or in the code that supports counting the 20-day deadline from the second-tier canvass of the vote, just because this school district happens to be located in more than one county.
Mr. Greiner, do you have any questions?
Can I respond just to that?
Sure.
So, again, without being repetitive, the code specifically references that it's the declaration of passage. Obviously, passage of the public measure could not be declared until all the votes were tallied for all the counties at the final vote. Additionally, with respect to reference to the bond, although we don't think the issue needs to even be approached because we think it's clear that the statute in and of itself requires the 20 days, or dictates that the 20 days runs from the date of passage. It is, in this case, in any event, we believe the contestants substantially complied with the statutory requirements. Mr. Greiner had taken bond money to the county auditor prior to December 3rd, handed him the money was taken, he was given a receipt for that payment, but before leaving the building, was returned the money and the receipt taken back by the county auditor, indicating that the appropriate thing to do was to submit $3,000 in cash, which was thereafter done. And so, again, I don't think we even need to get there because I think the law is clear. With respect to a case directly on point, Exhibit 6 page, starts at page 6, page 15 is, no, wrong page. Exhibit 6, page 20 is a case of Ferguson versus Henry. It's an old case, it's from 1895. But in that case, it was argued, I mean, it was a similar situation where there were multiple precincts. Back then, they called it the review of, there was essentially a first and second tier canvass of the votes, and the one party argued that the 20 days ran from the initial canvass, and they disagreed, and the case specifically says that is from the final canvass of votes from which the winner is declared that the 20 days runs. And so it's very archaically written, again, because it's from 1895, but that's essentially a couple different cases.
And I was not there then. Mr. Greiner, do you have any questions?
Yes. I found out later on that once you give the auditor some money, he cannot give it back to you. So there's some law or something about that. I found when I went through my stuff. I've been going on this for probably days at nights. I'd stay up and read through the books. So once I handed him that $300, he was supposed to accept it and keep it.
Is there a question?
Yeah, you need to ask a question if you got one.
Okay. I give him $300 on the 27th, so that was way before the first canvass is even done. And he should have kept the money, so you don't have no jurisdiction on this thing at all, basically.
Yeah, I think maybe it would be helpful to think about a hypothetical here though, because so the school district is located in 3 counties. Washington County is the controlling county. They're also in Johnson and Louisa County. Say that Johnson was the controlling county for this election. Washington County would have conducted its first tier canvass on the same date that it did, November 13th, if I'm remembering right. And after that, Washington County would not have taken any additional action on these election results. So if someone wanted to challenge Washington County's canvass of the votes and what happened in the Ainsworth precinct, they would have 20 days from November 13th to do that. The only reason that we're here making these arguments about the first and second tier canvass is just because Washington County happens to be the controlling county for this school district. And that's what, I think that's illustrative of why that deadline runs from the initial first tier canvass of the votes in the school district, election or any other elections.
Let's just ask Mr. Ruth if he has any questions. Do you have any questions?
I do not have any questions.
Do you have a follow-up question?
Yeah.
You really, we have to kind of ask questions to clarify things with which we make our decision. This isn't.
Okay, I'm sorry, but
You're-
I'm not very good at,
That's okay, I'm just trying
I
to.
fix fenders, I fix cars, I don't play with this stuff, okay?
That's why I'm here.
Okay, so the election was soured by 96 votes, and that doesn't mean anything to you at all. Is that what you're trying to tell me?
I'm not trying to tell you that then.
So why are we just, okay.
Ms. Colby, I have a question. How do you get past the language in chapter 62 that says that it's when it declares a winner? And if you go back to the canvas, chapter 20, then the auditor in the control county is supposed to issue a certificate, and that certificate goes to the school district. And no certificate was issued after the 13th, only a certification of the canvas, and then awaiting the second tier.
Yes, but if we do look at the certificate of election that was issued, which I think is Exhibit E, it does reference the fact in the certificate that the votes that were cast at this election were canvassed by the Board of Supervisors of each county that conducted the election. And then it describes when that took place. And then it references the fact that, again, there is that second tier canvass. And so I think, you know, when we have this situation with controlling counties and second tier canvasses versus the first tier canvass that takes place in the actual county that conducted the election, the way the code reads is that 20-day deadline would still run from the initial canvass. Otherwise, we are left in a situation where we're going to have different deadlines running depending on what the makeup of the school district is.
Well, if you have, in the Melma case, because I'm acquainted with that one pretty well, that district is just in one county. So a first tier canvass stops, the first tier canvass is the point at which you have a declaration of a winner.
Yeah, and I think at that time maybe this is, go ahead, Beth.
If I may, up until 2019, the control county conducted all of the elections, even if schools were located in other counties.
That's right.
So up until 2019, there was only one canvass of all votes. There was not a first tier canvass or a second tier canvass, and that happened after the legislative session in 2019.
Right. But we have to take the statute as it is today, and the statute today in 5024 talks about a first tier canvass and a second tier canvass, and then the provisions of chapter 62 particularly talk about declaring a winner. If you go back to 5024 says that when the canvass is complete in a multi-county district, then the auditor of the controlling county issues the certificate. The certificate wasn't issued after the first tier canvass here. In this situation, it was issued after the second, which would indicate that the question passed. 62 says that it's when you declare a winner. The legislature could be clearer, and I intend to write the Secretary of State when we're all done with this. But he isn't going to consider some retired lawyer from Ottumwa to be dispositive of this, but I think it needs clarification. I agree that it's not perfectly clear, but I think that when the statute says you declare a winner, that also declares passage. And I think at least that's my thinking at this point. Is there further?
Our only argument would be that's what the first tier canvass does, is declare the winner for each county in which the school district is located.
And in 50.1A where it talks about canvass of officials, it says that county, they're going to canvass the vote, they ascertain the results of the vote, and then in 62.5 it refers to 20 days after the Board of Supervisors declares a winner from the canvass of an election, which is exactly what Washington County was doing here in the first year canvass, when they were canvassing their own election and declaring the results from Washington County.
Right, but 5024 says, and that provides for that provision for the second tier canvass, I think. Okay, any other questions?
No.
Greiner, Mr. Ruth, any questions? Any response, Ms. Fink?
No, thank you.
Okay, let's, we'll take that, we got that decision to make, and we'll do that in due time after there's no need for us to adjourn and then come back, because people will lose interest in what we're doing. So, let's proceed, and I think now you have it's your turn, because you're the proponent of this, the contestant, and you can proceed with regard to the contest that's being made.
Mr. Gaumer, my understanding that Mr. Whitmer was going to be present today. And
Said he was.
Not going to be required to be.
I believe he was going to be here also.
Yeah, he at our meeting, he said he was gonna be.
Yes.
Yeah.
And so, my primary witness is Mr. Whitmer.
Okay, do you have any other witnesses? We can ask Mr. Whitmer, does anybody know that Mr. Whitmer is not attending? I mean, he's not attending, obviously, but,
Last
anybody-
week, to my knowledge, he was going to be here today. I haven't spoken with him today.
I believe he confirmed that at the initial meeting as well. I haven't heard otherwise.
I'm sort of reluctant to continue this, but, based on what I have read, and I will study your brief more, I have an opportunity to study theirs. And I expect the rest of us have, the panel has. I don't know that there's a lot of factual dispute. Do you think there's something, I mean,
So I think the undisclosed facts that Mr. Whitmer has in his brain is how the ballots were initially established, how they were, divvied up and provided to the precincts, why the precinct originally, only used one ballot. How it became known that
are you
there was an
wanting
issue.
to verify that somehow you have to comply with the election challenge under the error provisions? I mean, I don't think there was fraud. And I don't think anybody's alleging there was fraud. I think it was a mistake by the precinct official. Don't you?
Well, I'm not sure if they even had the right balance to begin with.
You can,
Say, may I step in for Dan as the newly appointed auditor?
well, that's up to Ms. Bain. She was here before, I mean, that's an audit, she's the deputy auditor before.
She's not
Right.
She's now the auditor.
I'm willing to answer the question if you would like
Well, you're the one that ultimately determined there was 96.
that. Right, the precinct did have both ballot styles. The poll workers were apparently unaware that they had two different styles, and we were made aware of that. Don't quote me on the time, I believe it was around 1 o'clock that afternoon. We were alerted that the correct ballot style was not going out to everybody. But they did in fact have both ballot styles, but they were not aware apparently that they had two.
So only a singular ballot was being used.
Right, but now whether it was going to people in Highland School District or people not in Highland School District, we have no way of knowing, who in fact got which ballot at that time.
And then there were multiple references in various newspapers of the possibility that district voters who were entitled to vote on the measure were not.
It's potential, or it's possible depending on who that voter was going through the line when the wrong when the wrong ballot was being passed out.
And I'm specifically referring, so it looks like, and Mr. Whitmer made the statements, which is why I was going to ask him about them. So he was quoted in the Southeast Union paper on November 6th, initially saying that there were complaints that persons actually living in the district did not get a ballot that had the public measure on it.
And that could be possible depending on which ballot style was being given out that morning and who the voter was going through, because there could have been voters, there would have been voters not in the district and voters within the district at that time.
I'm sorry to interrupt. I do want to object that the grounds for the petition state only that ballots were given to voters that did not live in the Highland School District. So this is a new ground that has not been raised before in this contest.
Well, but there's no doubt about that, is there? I mean, there's no doubt that you're not contending that some people from outside of the Highland District got ballots that contained the VF issue.
Correct.
That's correct. We are not challenging.
And my point was meant to underline like what happened, because of the allegations immediately following the election were voters who lived in the district may not have gotten the correct ballot with the actual measure on it. If we were only using one ballot, which included the measure, then everyone should have gotten a ballot. So the question is, why was this coming up immediately following the election if only one ballot was being used?
Well, we were using, they had two ballots,
Yes, two
correct?
ballots were being used, but only one got distributed in the beginning. The poll workers only opened one packet of ballots and distributed one. Both were being used, they were both at the polling site, but the poll workers had only, and I don't want to place blame on poll workers, but they had only distributed in the beginning the one ballot style, regardless of what that individual voter's ballot style stated on their voting record. So both were available, they just failed to open both packets and see that there were two to be given out.
And then you got that corrected at about
I
either
would say 1
between
o'clock
1
or
and
so.
2:30 or
Yes.
something like that.
So then, given that we know 96 ballots with the public measure had been distributed and cast by non-resident voters by 2:30 in the afternoon, then my assumption is the packet of ballots that was opened would have been the packet of ballots with the public measure on
I
it.
assume.
So if the ballots passed out until 2:30, all included the public measure on it, I was wondering why then there were various concerns or suggestions reported to the paper that people in the district may have received a ballot without the public measure on
Right,
it.
I don't know, I said I didn't make the statement as you said on some of this, so. And I don't know for certain which ballot style was given out in the beginning, so I don't really have an answer for that.
And another area I was going to ask Mr. Whitmer about is with respect to the final canvas numbers. So in the district's brief, and their supporting exhibits, it suggests there were 2,219 total votes cast, which Exhibit B shows 1,302 in favor and 381 against, which is consistent with Exhibit 4-1, which is the 11/13/24 canvass by the board. And then the additional counties that were reported shows, Exhibit C shows that Johnson County had 58 yes and 28 no's. And Exhibit D shows Louisa County had 0 yes and 0 no's. But then the vote, the canvass of votes done on November 19th shows a total of 2,222 votes, which is 3 more than the district's documents show. And there's no explanation where those additional 3 votes, it's 1 additional yes and 2 additional no's. Do you know where they?
I would have to go back and review, we balance to the ballot when we're done. The Exhibit B is only, well, it does show the total, I'm sorry. It shows the total of all of them. I don't know, I have not looked at that, to be quite honest, but we do have to, per Secretary of State, account for each and every number must balance. That's something I can sure look at, but I have not looked at those numbers.
And so, do you know if the number then is what is represented in Exhibit 4-2? The official number of votes?
That was what was canvassed at the second tier for all of the 3 counties total, would be the number, the 2,222 votes that were all accounted for. That's what was canvassed on the 19th, covering all 3 counties.
And that is the official?
That's the official for all 3 counties. The Washington County's official is on your first tier. So this is the official when all 3 counties are added together.
But as you sit here, you don't know where the additional 3 votes came from?
I would have to go back and look at all the numbers involved. They should add up to the total, obviously. And I can sit here and look through them right now if we want, but I don't know that 3, well, they should be represented on all of your exhibits that are here.
So what I'm
There's a
telling you
total canvas for Washington County plus the 2 from the other counties.
And I'm telling you, they don't add up.
Okay, and I'm not doubting you, I just think I
Yeah.
have not looked at
So,
that.
there's a difference of 3 votes.
Okay,
And it's unclear where those votes come
Okay.
from. And so I'm gonna ask Dan as the Commissioner of Elections if he knew where these
Okay.
additional 3, the
Um,
source of the additional 3 votes was.
okay.
Do you have additional questions for Ms. Stewart?
Ms. Stewart, do you have knowledge that Mr. Greiner came into the auditor's office on November 27th and provided $300 to?
I do know that he did, but I also know it was determined that that was not the bond amount required.
And so, am I correct in understanding that Mr. Greiner provided Mr. Woodmer with $300 cash? Mr. Woodmer gave Mr. Greiner a receipt for that $300,
To my knowledge, that would be our standard procedure.
but before Mr. Greiner left the building, Mr. Woodmer said he didn't think that was the proper procedure.
Correct,
Gave Mr. Greiner his $300
correct,
back
that's my understanding.
and took the receipt back.
My understanding, yes.
Then the $3,000 bond was paid to the auditor's office along with the affidavit on December 6th of 2024.
Let me find the receipt. Yes,
And is there any contention that the individuals who signed the petition are not appropriate persons to have signed it?
not to my knowledge. I did not actually in that position to do that lookup of everybody. To my knowledge, they were all valid.
How did you determine that there were 96 out-of-state, out-of-district electors that cast ballots for the public measure?
They weren't out of district, but, well, out of school district. I don't know who cast what vote. What we do know is that there were, out of all of the voters that went through the system, we can verify how many were of each ballot style. There were 96 voters processed that's a 96 number different than the actual number of ballots that went out. So we know the set number of ballot styles that should have been issued based on the voter versus the physical count of the ballots themselves. That was a 96 difference.
So 96 ballots without the public measure should have gone out.
I don't know who received what kind. I don't know which way it went, who received which ballots. I just know from our records that there was a 96s.
So that I'm clear, 96 people who were not Highland District residents voted in the Ainsworth precinct.
Received a ballot. May not have voted, received the ballot.
Okay. But you don't know what ballot style they got.
And we have no idea if they even voted for the measure.
Well, again, my understanding is that up till 1 o'clock or 2:30 of election day, there was only one ballot used, and it was the ballot with the public measure. So if we're deducting logic, they would have received the ballot with the public
Okay,
measure
that
on it.
I do not know about. I just know we have that discrepancy of 96 and that we were notified at 1 or 2:30. Like I said, I don't know the exact time.
Well, irrespective of the time, I thought you said earlier that 2 ballot styles were given,
Mhm.
one with the public measure on it, one without it.
Right,
Only the ballot with the public measure on it was used initially
okay,
until
whatever time.
right?
Right, yes,
And so then the deduction is 96 out of district voters received the only ballot given out.
right. Whichever ballot was given out was what those first people received.
And if the ballot, so you're saying, right, as you sit here, you don't know which ballot was given out?
I do not, my own personal knowledge, I do not know which ballot style was given out initially. I just know what the difference was between the correct number of ballots versus the number of processed voters. I do not know for certain which packet of ballots they had open that morning.
Let's just take a little break. Some have to use the restroom, so if anybody, I'm not sure where it is, but I'm sure some will find it.
I'll find it downstairs or something.
Hope you're enjoying this podcast episode. They took a little break, so this is my time to tell you to remember to like, follow, and subscribe. It's free.
Ms. Fink, I didn't want to short circuit you, but we had kind of a call, so is there further?
I'm just looking through my own.
Sure.
Ms. Stewart, do you have any personal knowledge, or were you present when the Washington County Board of Supervisors canvassed the abstracts and
I was present at the board meeting.
both times?
Yes.
And Mr. Whitmore was attested both of those as well.
Yes.
If the 96 ballots that were declared to be in error were all cast in favor of public measure VF, and they were set aside, the public measure would not have passed the 60% requirement.
I have not done that math. Our elections coordinator would have done that at the time.
Those are all my questions from Stuart.
Ms. Colby?
Yes, thanks, Ms. Stewart. I want to talk or look a little more closely maybe at the numbers that were being discussed earlier about the 96 votes. So if you could look at, let's start with Exhibit B, which is in the black binder, I believe. And if we look just at the Ainsworth precinct, which is on the far left column, it's that first one, we can see there's a total under yes of 246, correct?
Correct.
So that's 246 people voted yes on the public measure.
Correct.
Okay. And then 256 voted no, correct?
Correct.
And then there's a column that says undervotes, and it says 41. What is an undervote?
That would be people who did not vote for anything in that, with this being a vote of one, filling in one oval, those 41 did not vote on that measure.
Okay, so they had a ballot with the public measure on it, but
Correct.
it was not filled out.
Correct.
Okay, and then there were 0 overvotes. Is it an overvote where you fill out like both?
Yes and no.
Okay.
Correct.
Okay, and then there's a total column, and that total column includes, am I right that the total column includes the yes, no, and the undervotes?
Right, that is all ballots given out.
Okay. And earlier you were being asked about a potential discrepancy in exhibit, I think it was exhibit 4-1 in the white binder.
Okay.
And I believe, so if you go, I'm sorry, 4-2 maybe was where the question was about. And here it says there were yes votes, 1,361, no votes, 861, and then there's a total of 2,222 votes, is that correct?
Correct.
Does that total also include any undervotes or overvotes?
No, that would count only the votes that were cast properly, let's say properly.
Okay. And when we're thinking about these 96 ballots, those 96 ballots were handed out, correct?
Correct.
And they had the public measure on them.
Like I said, I'm not sure which ballot, from the sounds of it, it sounds like that was the bundle opened first.
Okay,
Prior, I did not know which.
okay. But we don't know of those 96, how many people voted yes, is that right?
Correct.
And we don't know how many voted no?
Correct.
And could there have been people who did not fill out the public measure in those 96 ballots?
Most definitely.
And I just want to make sure that we're all on the same page here. You're not aware of anyone who voted in the Ainsworth precinct who was not a registered voter in the Ainsworth precinct, correct?
No,
They were
no.
all supposed to vote there.
Correct.
The only issue is if they got the correct ballot.
If they were in the wrong precinct, they would have been directed to their correct precinct.
No other questions?
Follow up? Ms. Fee?
Yeah, I'm not, that's okay, not good.
Sure.
anything in addition to what I've already had.
All right, thank you. Mr. Greiner, any questions for Ms. Stewart?
Ms. Stewart, when I'll make this into a question. The first ballots they put out in the Ainsworth thing at, when I was there at 8:30, it was just the one for the Highland school bond issue only.
Okay.
I was number 60, okay? And I know someone went in there, that's not a question though, I don't. At 2:30, they figured out they was giving the wrong ballots to people, okay? Because at 8:30, I asked the question to the lady. My co-worker was in Crawfordsville County, you know, supposed to vote for, well, Waco School District, that's it. And he got the same ballot I got. That's why I'm here today, because I knew it was messed up for him, okay? And it didn't get fixed really until like 2:30 that afternoon.
When we were made aware of it.
Yeah,
We were not aware of it.
2:59, that's when the last person, when they started figuring out it was wrong.
Okay.
But the lady at 8:30 told me, it doesn't matter, I'll be quiet, that's not a question. Okay, I'm done.
Mr. Ruth, any questions?
Did Mr. Greiner call your office at 8:30 in the morning?
To my knowledge, no. We were first made aware of it at
All right.
that early afternoon timeframe.
Okay, thank you.
Is there, in your system that you have for voting, can you tell when a person voted?
Probably not. We can probably tell when they were processed, and I'm not that familiar with the program. We can probably see when they came through the line. We would have no idea how long they took to cast their ballot, if they were one of them that were destroyed, damaged, redone. We could, like I said, possibly see when they came through the line, but I do not know that for fact.
So it's safe to say that we really cannot determine anything about the 96 people that were from out of the Highland district, other than they voted that day.
Correct.
As a result of the questions from the panel, anything further, Ms. Colby?
No.
Ms. Frank?
And I think that covered it, including there's no way to find out the individuals' names or how they voted.
There is not.
Do you have other witnesses?
No, other than I still feel like Mr. Greiner should have the witness.
Do you want a continuance for, I see in the statute that I do have authority to continue this thing. I can say without hesitation that Mr. Whitmer indicated that he was going to be here. Oh, nothing adverse happened to him or anything like that, but he, at our meeting, he was here. He was still the auditor then. And he indicated that he did not need a subpoena, and Mr. Greiner asked that question if he needed a subpoena, and he said no, that he would be here. Is that your recollection, Mr. Rep?
It is.
Yeah.
I guess it's worth noting that that would have been before it was moved from this date, from the original date. So I don't know. I can't confirm if he would have got notice of that. But as far as I know, Mr. Whitmer is local. So I don't know if a continuance is necessary or if there can be some attempts made to contact him.
I'm willing to do a short adjournment to see if someone can get him here, if someone has his phone number.
Well, let's, it's 10 o'clock. Let's take a short recess and you can give him a call. Somebody can give him a call and maybe he can come.
Okay.
All right? Thank you. We'll reconvene when you tell me what the result of your call is.
Has anybody seen Dan Widmer? Dan, where are you? Hey, while they're looking for Dan, I wanted to remind you to give this episode a like and make sure to follow and subscribe. Let's see if they found Dan.
Okay. I think we've reconvened. Ms. Fink, Mr. Whitmer's here, and that's, your absence is noted, but it's okay.
Again, I'm so sorry.
It's all right.
Well, thanks for coming in.
No problem.
So some of the questions Ms. Stewart was able to address in her capacity as the auditor presently, but I did have some questions for you relevant to when you were holding office.
Sure.
So as I understand it, you were also the designated Commissioner of Elections
That is correct.
for Washington County?
Yes, it's, the position is actually Washington County Auditor and Commissioner of Elections, so it's kind of.
And what is your understanding, your role with respect to the Commissioner of Elections is?
My understanding is that I was ultimately responsible for all functions of the, of any public election in Washington County. General elections, special elections, the elections that are held in the primary elections, school, city, anything like that.
And is it your understanding that on election day, the Ainsworth precinct was only handing out a ballot with public measure VF on it, irrespective of if the voter lived in the school district or not, until sometime in the mid-afternoon?
Yes, there were two different ballot styles that were applicable to the Ainsworth precinct, and they were all, both ballot styles were identical except for the one ballot style also, in addition, contained or included the question of the Highland school bond vote.
And then at some point in the day, was it brought to your attention that out-of-district voters were being provided ballots with the public measure on it?
Yes. It was probably early afternoon, 2 o'clock or so.
And then what was done to correct that?
Well, the first thing I did was contact our county attorney, and then we contacted the Secretary of State's office. No, excuse me, he contacted a judicial official at the state level.
And at some point, direction was given to the individuals in the polling location to use 2 ballots instead of
Yes,
one?
they were already aware of it when they called and said, basically, oh, we've made a mistake, we just discovered the mistake, and we were inadvertently handing out the wrong ballot to people, the voters.
Now, I just wanted to clarify, there were several newspaper articles written up about the subject matter, and in, for example, the Southeast Union paper article on November 6th, it references you stating that some constituents living in the district were not given ballots that included the proposed bond measure.
That was my understanding, yes,
At the time?
at the time.
Okay.
Mm-hmm.
And so, fast forward, you were not aware of any issue of in-district voters not being given a ballot without the public measure on it?
No, I wasn't. There were so many stories floating around, and calling me and with, you know, their account of the issue, and so at that point, I was still trying to really determine, okay, did voters receive a ballot which should have included the Highland School Board measure and it was not included on their ballot? And flip side, did people that did not reside in the Highland School District receive, I'm getting myself, vice versa, is what I'm trying to say.
After it was brought to your attention that ballots with public measure VF were provided to out-of-district voters, your initial impression was there would likely need to be a new election.
That's where some of the difficulty resulted from, because in working with our county attorney, we soon learned that fortunately this had not happened in recent memory, or there was a lack of what would you call it? Precedent. Thank you very much. That's the word I was looking for. A precedent for something like this happening. And so, and we also discovered, or counsel from the county attorney, that code was somewhat contradictory on the matter, as well as what should be done. And so that was kind of my approach, is that we have to sort through this and figure out what the protocol was, and that's where it got interesting, for lack of a better word.
I'm gonna hand you a book that
Sure.
has some exhibits in it. And would you turn to exhibit 4 for me?
Certainly.
And exhibit 4, page 1, turn back one more page. Nope, the other one. Page 1, you agree is the abstract of votes of the Washington County Board of Supervisor of the votes cast in Washington County.
Yes. Mm-hmm.
Also referred to as a Tier 1
Mm-hmm.
campus,
Mm-hmm.
correct?
Yes.
And you attested, you were present when this was signed and attested to it?
Yes, yes, I was.
And as a result of, well, on November 13, 2024, was there a declaration made that the public measure VF had passed?
So, could you say it again, please?
I'll ask it a different way.
Okay.
You agree that there was no declaration of passage as of November?
Oh,
13.
yes, this was just merely a canvas of the votes, whether
Of just
right, wrong, or
Washington?
indifferent, yeah.
And then there was a second or final canvas done,
A second tier was done then approximately a week later.
and that is exhibit 4, page 2,
Yes.
and you were present and
Yes,
attested
I
to
was.
that as well.
Mm-hmm. Mm-hmm.
And following this canvas, at that time, the Board of Supervisors, acting as the Board of Canvassers, declared that the Highland School District Public Measure VF had been passed.
This is just a canvas of the. Yes, that is based on the votes canvassed. The Highland ballot issue was passed.
And then following that
Mm-hmm.
second tier canvas, the
Mhm.
code then requires you as Commissioner of Elections to certify the election results,
Mm-hmm.
correct?
Mm-hmm.
And Exhibit E, which is not in that book, but I will provide you with a copy,
Mm-hmm.
is that your certification of the election,
Yes, that's my signature.
and that's what the document title states.
Certificate of result of elections, yes.
And that certificate was given following the final canvass conducted,
That second canvas, yes.
correct?
Mm-hmm. Mm-hmm. Yeah, 21st of November.
And were you present when throughout the entire canvass done on
The
November
whole
19th?
process, yes, I was.
And do you know from what document, so to speak, the final canvass was made from by the Board of Supervisors? So for example, if you go back to Exhibit 4, page 2. It indicates there were 1,361 yes votes,
Mm-hmm.
861 no votes, for a total of 2,222 votes.
Yes.
And do you know, like, what the actual documents that were used to confirm that?
It would have been. It would have been the two canvases that took place.
The district's exhibits B, C, and D represent, my understanding, B is a representation of the numbers of the initial canvass of just Washington County. Does that look
Yes, that looks.
to be the case? Well, that's the
Well,
entire page.
1302 and 831, yes. Yes.
And then Exhibit C represents that for Johnson County, the public measure received 58 yes votes and 28 no votes.
Yes.
And that's not
Yeah.
spelled out
Yeah,
in
right.
Exhibit
That's what we
4-2.
would have, that's what we received from Johnson County. There's probably one from the ones as well.
And then Exhibit D, page 5. Again, you don't have it, I'm showing it to you.
Okay.
With respect to the Highland School public measure, it indicates zero votes.
Yes. Correct.
So if I add up, anyone adds up, B, C, and D, the yeses and the nos, the numbers actually come out to, one more, well, the numbers actually come out to, I've got it right there. $1,360 yeses and 859 noes. So if I add the yeses and the nos from these three documents. But in Exhibit 4, page 2, the number of yeses certified is 1,361. Do you see that?
Mm-hmm.
And the number of noes certified is 861. Do you know where the 3 additional votes came from?
I do not know. I told her earlier, I had not looked at those numbers, not needing to at the time,
Yeah, 'cause I know
but we
you-
are 3 off.
You worked on that
According to this,
quite a bit. and-
according to this. we
Yeah.
are.
No. No, I don't.
Switching gears, with respect to the petition Mr. Widmer filed on November 20th of 2024.
You mean Mr. Greiner.
Thank you.
Me,
It's all right.
Let me rephrase that.
Oh, it's okay.
With respect to the petition Mr. Greiner filed on
Mhm.
November 20th,
Mhm.
2024. After he filed it, did you call him to have a conversation about the need for a bond?
I don't recall for sure if it was by telephone or not. I know that there were discussions that took place with regards to the requirements, and one of those requirements was providing a bond. Mm-hmm.
And then, do you recall on November 27th, that Mr. Greiner did in fact come into your office and provided you with $300 cash?
Yes.
And at that time, you gave him a receipt for the $300 cash?
Mm-hmm.
But subsequent to Mr. Greiner leaving the building, you stopped him and said you didn't know if that was appropriate procedure?
We discussed it more, and just while he was at the counter, I got to thinking about it and gave it some further consideration, and that's when I gave him the money back, and I believe we went down and spoke with the county attorney down in his office on the bottom floor of the courthouse, and determined that I think, was that when there was I'm trying to remember now, if that was the question as far as the date. No, that was something else. So anyway, yes, we went down and spoke with the county attorney, who I believe advised that that a bond was needed. And I believe then at that time we also discussed the when that needed to be provided, and those sorts of details.
In my understanding, Mr. Greiner was told that he could either go obtain a bond on his own through a bond
Mhm.
company
Mhm.
or
Mhm.
pay $3,000 cash,
Yes.
correct?
Mm-hmm.
And he was told to have that done by December 9th.
Yes, there was some discussion about that because of the time frame. Code says it was, let's see, how many days was it again? From 20, thank you. from 20 days, and then we kind of then the question arose 20 days from which canvas, the first canvas or the second canvas for the surrounding counties, just to add a little bit more need for detail, or dare I say confusion, as far as what was going to be needed. And so I believe what we said was, again, there was confusion, and that it would be the safest thing to do would be to use the first the sooner of the two deadlines to alleviate any confusion, doubt, or anything like that. Because again, it was still kind of, murky as far as which canvas to use, the first one or the second one that took place approximately a week later.
Do you recall if Mr. Greiner was told the deadline to post the bond was December 9th? Which would have been 20 days from the second canvas.
I believe that we said that it was recommended that he I'm trying to remember, that he use the sooner of the two to be on the safe side, but that it could also be interpreted that the time period would begin on the second canvas.
And on December 6th, 2024, Mr. Greiner came to your office and provided the $3,000 bond and submitted with that an affidavit, correct?
Yes. There were actually two individuals that provided, or there was another individual that provided part of the cash as well. But between the two, Mr. Greiner and the other individual, it was $3,000 cash.
Thank you, those are all the questions I have for you.
Okay.
Questions, Ms. Colby?
Thank you. Going back to exhibits B and C, do you have the, I'm not sure if you have those.
I was letting you
Here,
use mine.
oh, me and use one. Okay. Oh, you have one?
Yeah, I got it. Actually, it'll be C and D, my bad.
Okay.
But earlier you were being asked about the county's second tier canvass of the votes and a potential 3-vote discrepancy.
Mhm.
And I want you to just take a look at Exhibit C, which is that one right in front of you.
Okay.
And then at the top you can see, I should look at it. You can see up there, there's a date on there, 1/10/25, and it says election night recording. You see where it says that?
Oh, up here in the corner?
Yeah.
1/10/25, 9:16 a.m.,
Yeah.
election night reporting, yes. that's
You
right.
would agree, that's not the information that you would have received as the control county from Johnson County, correct? You would have gotten the actual election results from the county.
Yes, I agree.
Okay. And then if you look at Exhibit D,
Keep on.
yep, sorry, there's a tab right there that says D.
Oh, that would make sense, wouldn't it? Okay.
And same thing there, you would have gotten, is that the document you would have gotten from Louisa County, or would you have gotten something else from the county for their results? From their canvas?
I believe we would have gotten something else.
Would you have received an abstract of votes?
Yes.
Similar
believe
to
so.
what Washington County did is Exhibit 4.1.
Yes,
Each
I
county
believe
would
so.
have
I
provided
believe
you
so.
with an abstract of votes.
Mm-hmm.
And is that what you would have based your second tier canvas on instead of these reports? The canvases received, the abstracts received?
I believe it would have been from that second canvas.
Well, let's take, so each
Okay.
of the 3 counties does their own first tier canvas, correct, of their election?
Yes.
And then Washington County is the control county?
Mm-hmm. So they would have been doing their canvas, their first canvas or maybe their only canvas, I guess. On, well, not necessarily the very same day that we did our first canvas, but
Right around
as
there?
you know, there's a narrow window, so it would have been approximately the same.
Okay.
Mm-hmm.
And I think so if we look at Exhibit 4, which is Washington, that's the first tier canvas, correct, that that Washington County did.
Yes, yes.
Would you have received a document like that from Johnson County and Louisa County for Washington to conduct the second tier canvass?
Trying to remember if we would have gotten that, what we would have gotten from them. Frankly, those types of things are done by staff, and
That's fair enough. If you don't know, you
I
don't know.
don't know.
Okay, and I guess then my next question is basically, so Washington County, in conducting the second tier canvass of the vote, you are not at all relying on what's in exhibits C and D to do that. Those are just the district's exhibits, correct?
Right.
Right. So, in conducting this second tier canvass, where you have this abstract of the votes that's in exhibit 4, page 2, I believe.
You're in exhibit 5.
Sorry.
Oh,
Go back one.
go back and forth.
Yep, this
Here we
one.
go, here we go.
And I think that's the first tier canvas.
Yes.
So if you go to the next
Okay.
page, right here.
2001. Yeah, okay.
Okay, this is the
Yes,
second
yes.
tier canvas.
Sorry, it took me a while.
Nope,
Okay.
that's okay, but this would be these numbers here would be, you would have received those directly from the Washington County canvas, the Johnson County canvas, and the Louisa County
Yes,
canvas.
yes,
results,
yes,
correct? Okay,
yes.
any discrepancy based on those other exhibits we saw would not necessarily matter to this canvas of the
Right,
vote.
that's correct.
I don't have any other questions.
Anything redirect? Any further witnesses? School district?
No.
Any questions, Mr. Ruth or Mr. Whitman? Mr. Greiner, any questions? And Mr. Whitman?
Dan, on November 27th, I came in and gave you that $300 cash, and you give me a receipt and everything. So we did. I give you the money back. I mean, and you give me.
I gave you the money back.
I give you the receipt back. You give me the money back.
Mhm.
And he said we need to go down and talk to the county attorney. So we
Correct,
both went down.
correct, yes.
And basically, you guys told me I had basically till December 9th. Because we sit there and talked a while, and you said, yeah.
It was.
Yeah. But I mean, that's
I don't know
all.
if I describe it as a lengthy conversation,
Yeah,
it was
but-
definitely not a brief conversation.
No, it wasn't brief,
It
it
was
was
not
probably there
brief
by
conversation.
15, 20 minutes.
Yeah, yeah,
Yeah.
I agree.
So, that's all I wanted to know, is that you did tell me December 9th.
What I said, I think what we said.
And so did he. He told, we agreed it was gonna be December 9th,
Mhm.
before I walked out there.
Okay,
Okay?
Objection. These aren't questions.
You're right, it's not, but Mr. Whitmer, I'm gonna help Mr. Greiner, who indicated to me that he isn't in the habit of asking these sorts of questions. When you and Mr. Greiner went to Mr. Rupp's office, is it correct that you discussed the deadline for posting the bond?
we discussed that at length, and again, because of the confusion with the Iowa code, it was the period of time starting at the first canvas or the second canvas, and we were unable to really provide a clear-cut answer, but we did advise to be on the safe side to use the earlier of the 2 dates, as I recall.
Do you recall saying, but it would be satisfactory to use the 20 days following the second canvas? And if you don't remember, that's the proper answer.
I have to, I gotta tell the truth, I don't recall specifically. I know we encouraged him to seek legal counsel at different times during that conversation, but again, I don't recall anything other than recommending that he use the earliest of the 2 dates.
Did you, after the 13th, when you did the Washington County canvass, did you issue a certificate of election result and certify that to the Highland School District? Or did you wait until the second tier canvass?
We would have waited until the second tier canvass was complete when we,
And
for all
that
practical
would
purposes,
have,
had all of the votes.
and that would have been the time at which you determined the result of the election.
Yes, we had to wait until the second, to complete the second canvass.
How did, this isn't anything that's been asked, but how did you determine the amount of the bond?
I will be honest, that was based on the recommendation of the county attorney, because that was one of my questions. I knew it would come up at some point, is how much of a bond, and that was, again, the recommendation of the Washington County attorney.
And you and or Mr. Rep, the
Yes,
county
County
attorney,
attorney, yeah, Nathan Rapp. Mhm.
you had communication from time to time with the
Oh, yes.
Secretary of State's office?
Yes. Mhm.
And did they give you some, do you know if they provided guidance concerning the amount of the bond?
I don't know that. I just know that Nathan mentioned at some point that he asked me if that was a good estimation of the costs if another election, a special election was held. And I said, yes, I think that's reasonable. That's a good estimate.
And you understand the code requires you to approve the bond,
Mm-hmm.
and you did approve the bond of
Yes.
$3,000.
The bond amount, yes. Mm-hmm.
And when the $3,000 was used, Mr. Greiner proposed to post 10%.
Right.
And then ultimately you thought that was not acceptable, and that's this conversation
This
about
conversation that took
he
place.
posted and then you
Mhm.
gave it back and he gave you the receipt
Mhm.
back and so forth.
Yes, and for the record, I did return, I mean, before you ever left the office that day, Mr. Greiner, that, here's your, it was cash, and here's your cash back.
Mr. Ruth, do you have any questions? Mr. Greiner, do you have any more questions?
No, I'm good.
As
Thank
a
you.
result of my questioning, Ms. Fink, do you have any questions?
No, I do not.
Ms. Colby?
No.
I've never been that comprehensive, I want you to know that nobody has objected after I talk, but, okay, do you have any further evidence?
No.
Okay. I would like, because the code provides this, counsel, both of you, do some calculations. Because of the provisions of the Iowa Code that if, and I know you've addressed this in your brief, if we disregard the Ainsworth precinct results as canvassed by the Washington County Board of Supervisors, would the public measure pass by the required 60%?
Yes.
And that's your judgment. Ms. Fink, do you have a,
If we are disregarding the entire precinct's vote,
yes, because I believe that's what the code provides, that if the error which this record shows, that the result of this record is that it was an error by the precinct official. And I think, you know, we've heard that they didn't open both packets of votes. So if we determine, and I'm again not speaking for this panel, I'm just asking questions, but I want this information. If the evidence in this case, I believe, is uncontradicted, that there were 2 packets of ballots and the election official only opened the first packet of ballots for the VF, that contained the VF question, until sometime between 1 and 2:30, that's when it was determined that there had been a mistake in handing out ballots. That, you know, I think was innocent, but it was a mistake. If we disregard the Ainsworth precinct, does the public measure pass?
it does, but I would like to point out that 57.4, which references disregarding a precinct, applies on its face only to allegations that misconduct, fraud, or corruption is involved. So misconduct, fraud, and corruption are all 3 intentional actions of a public official. And the way that case law explains, setting it aside, is that the sanctity of an election should not be otherwise thwarted by the bad deeds of an official unless the result would change the election for the entire county. So I have included
But now if you go back,
57.4.
let me stop you there. If you go back to 57.1 sub 2, the only basis upon which the contest can occur, I believe, in the A through H provisions would be 2A, right? Which says, grounds for contesting an election under this chapter are misconduct, fraud, or corruption on the part of any election official or any board of canvassers of sufficient magnitude to change the results of the election. Because I don't think we have an incumbent question, we don't have a felon, you know, that's about an incumbent. The illegal votes have been received or legal votes rejected. I don't think we have a question about rejection of any, nobody was rejected. An error on the board of canvassers, I know we've got a little bit of a dispute there, but I don't think there's a canvasser issue, and that hasn't been alleged. The public measure wasn't authorized. that isn't an issue. And any other, in the great legislative catch-all, any other cause or allegation which if sustained, would show that a person other than the incumbent was duly elected, or would show the outcome of the election on the public measure in question was contrary to the result declared by the Board of Canvassers. I don't think that's alleged, but if you go then to 57.4, the only basis can be misconduct, fraud, or corruption. I don't think misconduct requires intent to, I don't think, the misconduct, they made a mistake. I think that's misconduct.
Yeah, that's negligence.
Well, that isn't in the grounds for contesting.
But, well, subparagraph H, which is to cover situations like this, provides that if sustained, would show that the measure would not have passed, which is why I provided the case law that I provided. I cited two cases, Harney versus Clear Creek, and
Is it the South Carolina case?
no, there's two Iowa cases on hand.
Hanahan, okay.
Yes.
Yeah.
In those two cases, the discussion about the effect of a wrong ballot is provided. And it indicates find it in my outline. Well, it essentially indicates that an election based on a ballot that has a material defect is invalid. And so these statutes existed back then. If the idea is that only these grounds apply, then clearly one or more of them were interpreted as allowing the election to be nullified.
You're not contending the ballot was defective, are you?
In the extent that it was given to non-resident.
But the ballot itself was not defective. If I remember the Boone County case, there they talked about what was gonna be proposed, and that was different from what the ballot was. And that would be a defective ballot.
So if you look at there's not an identical case.
Right, I agree, we're plowing new ground.
But in the Mr. case, in that case, the ballots given to the regular voters was correct. The ballots given to the absentee voters was incorrect.
To the non-resident.
The absentee. So,
Oh, yeah,
you know, the
Right,
voters at the poll and then the
absentee ballot was different.
was different and incorrect. And in that case, the court held that the fact that the absentee ballot was defective was sufficient to nullify
The whole
the
election.
entire
Right.
election.
But we don't have that here.
It's
What
a
we have is-
similar premise.
Yeah, I mean, the basis on what you're saying is that non-district residents could have voted for or against the public measure. And the reason for that was that the election official gave them the wrong ballot. But we don't know whether they voted for, against, or otherwise, right?
Correct.
I wanted to clarify that. Any comments, questions, or anything about it?
No, I mean, I think that's the crux of the matter, is that we don't know how any of those people voted, and there's nothing in the code that would allow us to presume that those votes were cast in a particular way. I think what is in the code is that exactly what we were just talking about, that in 57.4, any misconduct complained of does not give grounds to set aside the election unless, setting aside that particular precinct, it changes the outcome.
At this point, is there any other argument, comment, anything? Are you satisfied that you understand what the issues are?
Yeah.
Do you understand what the issues are? I hope I do. We're going to adjourn, and the three of us will stay in here. And unfortunately, those in the media, you don't get to hear our deliberations, but you'll hear our result, and we'll hope to have a result here shortly. Okay?
Thanks for checking in on this podcast and watching it, being a loyal viewer. And if you haven't subscribed yet and you like this episode, make sure to give this episode a like and then follow and subscribe. It's free. That way you don't miss out on a thing.
The election panel has considered all of the evidence as they're required to do. And the election panel has come to a decision. We have two decisions that we're going to make. First, with regard to the motion to dismiss for lack of jurisdiction, I believe it is a 3-0 vote. It was a 3-0 vote that motion should fail for the reason that the timeline begins when the canvass results in a declared winner. And so that would have begun after the second tier canvass, and the 20 days for the filing was complied with. The reason that I think we voted that way was first because the statute says when a winner is declared and then the Commissioner of Elections did not certify to the school district after the Tier 1 election, and so the Tier 2 election is when certification of the result would have occurred. The challenge about the misconduct in one precinct is not covered by the statute. It is triggered, and the election contest is triggered when the final declaration of success is made. So that was considered and voted 3-0 that the motion is overruled. With regard to then the merits that we went to, whether the statute provides that if the misconduct of a precinct official occurs, and if the result of elimination of the votes, not the consideration of the votes from the precinct in which the misconduct occurred, then if the election still would have passed, then we are to declare that the contest is overruled and the election should stand. Now, what happened there. And let me just, for those of you in the audience, Section 57.4 of the code says, when the misconduct complained of is on the part of a precinct election official in a precinct, and there's only been allegations that the mistaken ballots occurred in the Ainsworth precinct, it shall not be held sufficient to set aside the election unless the rejection of the vote of that precinct would change the result. The canvass that occurred on the 19th of November, with all of the votes, indicated that the public measure achieved the required 60% majority. If you eliminate the votes in the Ainsworth precinct, you still get a successful in excess of 60%. As a result, I think, based on the evidence that was presented and the record that was very ably made by counsel on both sides, it is a 2-to-1 vote of this panel that the election should be declared successful, and that the auditor now, Ms. Stewart, I think you are obligated as a result of this decision to certify to the school district that the election passed, received the required majority or super majority.
Yeah, 60 or over 60%.
I think that's what's required now, and even though you didn't conduct the election officially, it's your job now. And so I think that, and if you need help with that, you know a heck of a lot more about how to do that than I do, but I think that's, now, there was discussion among the panel, and significant discussion among the panel, that this isn't the right result. It is the result that's dictated by the law, but when there is a significant mistake, to do it over would have been another alternative. Unfortunately, we don't have that authority as an election contest panel to say, well, we don't like the fact that this happened and we should set aside the election. Whether officials, county officials, elected officials, anybody said that that's what should happen is irrelevant. I think when we considered this matter, we made the decision that the legislature has determined the way we're supposed to handle it. It has been an education, I can say, for all three members of the panel. We've learned more about election law than maybe we wanted to know, but we do know it now, and I think that's what's the result. So, thank you for your able service, Mr. Greiner, Mr. Ruth. We've gotten to know each other and had a good discussion, and I think we've finished our job.
Thank you all.
You're welcome, and I think each of us get $100. I'm not sure where that comes from, but that's, you can send that, you have the addresses of the respective people. So, thank you very much, and this concludes our hearing.
Well, I don't like this decision, and the reason I don't like this decision is they took out all of the Ainsworth votes. Well, if you were happy for it, it passed. If you didn't want it to go on, you didn't really, they still had a majority in the other districts, but your vote didn't count one way or another in Ainsworth. And to me, that seems like a wrong decision. And you know what? When things like that happen, we have to, as citizens, get involved, figure out ways to make things change and make things make more sense. I know people are trying to do that, and this is the way it turned out this time. Thank you for watching. Thanks to the sponsors, Greiner Auto Body, Car Doctor, McDonald Boneyard, Hinshaw Trailer Sales, Girling Repair, B&B Propane, and the family of Jet Stops, the Dutch Market, and Coffee Talk. I'm your host, John Bain. Stay friendly, Southeast Iowa.